আপনাদের সকলকে আমি আবারও আমন্ত্রণ জানাচ্ছি আজকের ক্রিমিনাল লয়ের উপর এই আইন বিষয়ক অনুষ্ঠান ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আজকের ভিডিওটা খুবই ইম্পর্টেন্ট, আমাদের একটু লেটে শুরু হয়েছে। আমি জাজের স্পিচটা শেষ করতে চাই। আমি কন্ট্রোল রুমকে রিকোয়েস্ট করছি আপনারা জাজের স্পিচটা যতটুকু পারেন পুরোটা প্লে করার চেষ্টা করেন।
The law prevents me from making an order which is greater than that which would have been imposed had you been convicted before December 2003. This principle, which I must follow, should be clearly understood. I emphasise it at this stage because, as will become apparent, minimum terms to be served before consideration is given to release on licence were in the 1990s and the early 2000s much shorter than would have been ordered today in 2023. In deciding whether to impose a minimum term, and if so, the length of that term before any release on licence, I'm required to adopt the following approach. First, to assess the term to be served by reference to contemporary principles set out in Schedule 21 of the Sentencing Act 2020. I must then identify the length of that minimum term before any release on licence, as would have been determined by the Secretary of State before 2002, by applying the relevant practice directions and other guidance available. If the minimum term to be served would have been shorter before December 2002, then I must apply that shorter term. Relevant findings of fact. I start, therefore, by considering the appropriate term which you must serve by reference to Schedule 21 of the Sentencing Act. In this context, I make the following findings, of which I am sure, having been the trial judge. You lured Nikki Allen away from the relative safety of the Garths by telling her lies. Only you know what you said to her to cause her to leave the Garths with you shortly before 10 p.m. on the 7th of October 1992, but somehow you tricked her into going with you in the opposite direction to her home and on a cold and dark night. You did not use force. A witness saw you both on your way to the old Exchange building, you leading the way and Nikki skipping along after you. The impression of that witness was that you were father and daughter. You didn't need to use force because Nikki knew you and she trusted you. The jury heard evidence that Nikki was shy and clingy to her mother, not a child who would have been inclined to go off with a stranger. But you knew Nikki's family and they knew you. Your purpose in luring Nikki away to the old Exchange building was sexual. You intended to sexually assault Nikki either in the grounds of the old Exchange building or in the building itself. You were aged 25 at the time. Nikki was 7 years old. There could have been no benign reason for your wishing to trick Nikki into going with you to an isolated derelict building. Using common sense, there could be no other reason for you luring her away as you did for anything other than a sexual reason. My confidence in this conclusion is fortified by my knowledge of your history of convictions for offences of indecency towards children of Nikki's age, and by your admission to the probation worker in March of 2000 that in your early 20s you were sexually interested in children of Nikki's age. Nikki did not submit to the sexual assault or attempted sexual assault. She must have resisted. And during the struggle, her anorak and shoes came off. She screamed and you struck her to silence her. You murdered her, intending to kill her, in order that she would not tell anyone about what you had done or had tried to do to her. You pushed her into the deserted and derelict building and then went in after her. Having struck Nikki over the head at least twice with a brick fracturing her skull, you then stabbed her chest with a knife, either a kitchen knife or a penknife, which you had taken with you. Your attack was brutal. You stabbed Nikki's chest and abdomen on 37 occasions. The stab wounds were deep many penetrating more than one internal organ. The T-shirt which Nikki was wearing bore no holes, indicating that the T-shirt had been raised above her abdomen when you stabbed her. I cannot be sure that you deliberately and intentionally raised her top, rather than it having become rucked up under her armpits during the struggle. I'm not therefore sure that the act of stabbing Nikki's naked chest had an overtly sexual element to it. You caused Nikki great mental suffering in the minutes before her loss of consciousness. After you pushed her into the old exchange building, she must have quickly known that you were coming after her to hurt her, and there was nowhere for her to hide. She was in a cold, pitch-black building. Her terror at what was to befall her as you stalked her in that building is unimaginable. You then took steps to conceal what you'd done. You did your best to hide Nikki's body by dragging her down into the dark cellar, where you dumped her in the far corner of the room furthest away from the staircase. No one would have been likely to have found her body had they not been looking for it in the cellar with a decent torch. You then covered yourself by giving false information to the police. You provided yourself with a neat but false alibi, claiming to have been away from the Garths, getting fish and chips for a friend at the time when Nikki was killed. You are now 55 years old. When you committed this murder, you were 23 years old. You appeared before the court on 22 occasions for 45 offences. The majority of your offending has been acquisitive, but your sexual attraction to 7-year-old Nikki Allen was not an isolated incident. In October 1986, you had been found to have breached the peace when you had approached a group of little girls between 8 and 10 years old. You took hold of one girl by the arm and asked to kiss her. You told the children not to tell anyone. In March 2000, so 8 years after your killing of Nikki Allen, you were convicted of an indecent assault upon a female under 14 years. 2 girls, aged 9 and 12, were playing in a park. You approached the girls and took hold of the shoulder of one of them. You told her not to scream. You asked the other whether she had knickers on. You then took hold of the front of her clothing, placed your hand between her legs, touching her vagina over her clothing. In connection with this offence, you were interviewed by a probation officer when you admitted that when you had been approximately 22 years old or thereabouts, you had started to fantasise about both adults and children, in particular young girls. You told her that you would think about young girls being naked and what it would be like to touch their body and have sexual intercourse with them. It's against this background that I address the first issue which I must consider under Schedule 21 of the Sentencing Act 2020. And that concerns whether to impose a whole life order. Paragraph 2 of Schedule 21 provides for a starting point of a whole life term in cases of exceptionally high seriousness. Paragraph 2.2 provides that cases which would normally fall within this category of exceptionally high seriousness include at B, the murder of a child if it involves the abduction of the child or it involves sexual motivation. In this case, the Crown does not submit that Nikki was abducted by force. As I've said, she was seen by witnesses apparently skipping behind you in order to catch you up. But undoubtedly you tricked Nikki by lying to her about something or other. You took advantage of her young age and her naivety, and of the fact that she knew you and trusted you as a friend of the family. I agree with Mr. Wright that even though no physical abduction took place, your use of deception to lure Nikki to the old exchange building approximates to the abduction scenario. The killing did not involve sexual motivation. I find no evidence that you were sexually thrilled by the killing. But the whole purpose of your tricking Nikki to go to the derelict building was, as I have found, in order to assault her sexually. The presence of these factors in conjunction with other factors which I've identified in my findings of fact have caused me to reflect very carefully upon whether this is one of those exceptional cases in which a whole life order should be imposed. Mr. Wright does not urge that course upon me, and on reflection, rightly so. Recent guidance from the Court of Appeal reminds judges that whole life orders should be imposed only where the facts of the case, considered as a whole, will leave the judge in no doubt that the offender must be kept in prison for the rest of his or her life. It's a sentence of last resort for cases of the most extreme gravity, and one reserved for a few exceptionally serious cases. Given this perspective, whilst undoubtedly a murder which will horrify all those who hear or read about it, I'm not able to come to the sure and confident conclusion that the imposition of a whole life term for the murder of Nikki Allen is appropriate. I am, however, wholly satisfied that the murder of Nikki Allen was one of particularly high seriousness, as envisaged by paragraph 3 of Schedule 21, and the correct starting point for the minimum term to be served is one of 30 years. Paragraph 3 of Schedule 21 sets out a list of features which, if present, would normally lead to the conclusion that the murder falls into the category of particularly high seriousness. It's a non-exhaustive list of examples only. The real question for me is whether, reflecting on the types of conduct referred to in those statutory examples, I am satisfied that there exist features of your murder of Nikki Allen which justify that description of Nikki's murder as one of particularly high seriousness. And I am entirely satisfied that those features do exist. I've already stated my conclusion that whilst you didn't physically abduct Nikki, what you did by tricking a trusting 7-year-old girl into going with you was very close to such a scenario. That factor, it seems to me, is one that I can and must take into account when considering the seriousness of the murder. That report, in any respect, is relevant to the minimum term which I must impose. Any intellectual difficulties which you face do not affect your culpability for this offence. You demonstrated quite sufficient guile to lure Nikki away from the Garths, and you were quick to attempt to cover your tracks by inventing a false alibi which you gave to the police. Nor do I accept that your age, then or now, is a relevant factor mitigating in your favour. At the time of this murder, you were an adult of 25. You were not a child or an adolescent who knew no better. You're now aged 55 years. The fact that as a result of the minimum term which I may impose, you may die in prison is not, it seems to me, a factor which I should take into account. Therefore, taking all of these factors into account, the minimum term which I would have ordered under Schedule 21 is one of not less than 37 years. I move on to stage 2 of my assessment, which is the Home Secretary's determination. I must now determine what the decision of the Home Secretary would have been before 2002 by applying the applicable guidance at the time. On the 10th of February of 1997, a letter was sent by Lord Bingham to all judges who made recommendations as to the appropriate term in murder cases. That letter advocated 14 years as the normal penalty for the average or normal or unexceptional murder before taking aggravating and mitigating factors into account. The letter went on to list the various factors which would likely call for a sentence mitigating the normal penalty. Those factors included subnormality or mental abnormality, and spontaneity or lack of premeditation beyond that necessary to constitute the offence. For example, a sudden response to family pressure or to prolonged stress. Lord Bingham listed the following factors as likely to call for a sentence more severe than the norm. They included the killing of a child or a very old or otherwise vulnerable victim, evidence of sadism, gratuitous violence or sexual maltreatment, humiliation or degradation before the killing, and the use of firearms or other dangerous weapons, whether carried for defensive or offensive reasons. Lord Bingham remarked that, whilst a recommendation of a punitive term longer than, say, 30 years will be very rare indeed, I don't think one should set any upper limit. Some crimes will certainly call for terms very well in excess of the norm. It's clear from the text of the Bingham letter that Lord Bingham was not himself setting the tariff. Rather, he was reflecting his own judicial experience and that of other judges in describing the level of minimum terms which were being imposed at the time of writing. A practice direction issued in 2004 said that in sentences where the murder was committed before the 31st of May 2002, the best guide to what would have been the practice of the Secretary of State is the letters sent to judges by Lord Bingham of Cornhill, the Lord Chief Justice, in February of 1997. I mention a further practice direction which was issued in 2002 by Lord Wolfe. Although of narrow date application, that practice direction refined the starting points for the minimum terms to be imposed. The range extended from a reduced starting point of 8 to 9 years for a case with reduced responsibility, a starting point of 12 years for a normal murder, for example, one involving a case involving the death of an adult victim arising from a quarrel or loss of temper between two people known to each other, a higher starting point of 15 to 16 years for more serious cases, for especially grave cases, for example, those involving what was described as a sexual murder or the murder of a young child, a term of 20 years or upwards would be appropriate. A term of 30 years existed for an extremely serious case. The practice direction stated that a substantial upward adjustment may be appropriate in the most serious cases, for example, those involving a substantial number of murders, or if there are several factors identified as attracting the higher starting point present. In suitable cases, the result might even be a minimum term of 30 years. And the categorisation maintained the possibility of no minimum term being imposed for cases of exceptional gravity, in effect the imposition of a whole life term. These recommendations were considered by the Court of Appeal in the 2004 case of the Crown and Sullivan, where the court found there to be no inconsistency between Lord Bingham's advice and the Wolfe practice direction. At paragraph 34, the court stated that while a judge might be helped to be consistent by the more specific guidance contained in the 2002 directions, their general effect is the same. Both give the judge a considerable degree of discretion. What I take from all of those materials is this. What was described to be a normal or unexceptional murder might attract a starting point for the minimum term in the region of 14 years. For the murder of a child or a murder associated with sexual conduct, a starting point of 20 years might be appropriate. A term of 30 years would be reserved for an extremely serious case, and the imposition of such a minimum term would be a rare event. In cases of exceptional gravity, a whole life term may be imposed. And finally, in all cases in which a minimum term was to be imposed, the court retained considerable discretion to take account of aggravating or mitigating factors which relate to either the offence or the offender in the particular case. It's in this context that I must stand back and examine your offending and determine where, within the range of starting points, the court would have placed that offending and what the effect of the many aggravating factors would have been. Both counsel agree that this is a case in which before December 2002, a minimum term of at least 20 years would have been appropriate. Mr. Wright submits that there would have been and should have been then a significant increase to reflect the multiple aggravating factors. Mr. Pitter that there should be little or no increase from 20 years at all. I'm entirely satisfied that before December 2002, a minimum term well in excess of 20 years would have been imposed. Lord Bingham identified the killing of a child, evidence of sexual maltreatment before the killing, and the use of a weapon, all as separate aggravating factors. All three were present in your case. Even from a starting point of 14 years, these factors would have increased the term substantially, in my judgment, to a point at or beyond 20 years. The court would then have to reflect upon the further aggravating factors which I've described elsewhere. There were, in reality, no mitigating factors. Although Mr. Pitter again relies upon your youth at the time of the offence, I reject that submission. You were 25 years old. The possibility that you may have died in prison or emerged an old man would not have arisen in 1992, even if, as Mr. Pitter submits, I must take the position as it is today. I'm still unable to accept that the possibility that you may die in prison is a factor which in any material way serves to reduce the minimum term. The murder of Nikki Allen involved the cynical manipulation of a young 7-year-old girl who you lured away from her home at night for the purpose of sexually assaulting her. You attacked her twice, once outside the old exchange building, and then the fatal assault. The fatal assault was brutal. You must have inflicted upon her unimaginable terror in the period before that fatal assault. You then took steps to cover your tracks by hiding the body to the extent that you could within that building, and by advancing your false alibi whilst another person stood trial for the murder which you had committed. I consider, having regard to all of those factors, that your offending was so serious that a minimum term of no less than 29 years would have been imposed. Any term less than this would not have reflected the recommendation of the trial judge or the decision of the Home Secretary at the time. I've given serious consideration to the conclusion that the combination of aggravating factors would have led to the imposition of a term of 30 years or more. Earlier conclusion that this is a murder.
দর্শক, এটা স্পিচটা আরো অনেক বাকি আছে। আমি একটু সামারাইজ করার চেষ্টা করব, তাইলে সবগুলো আমি সারসংক্ষেপে বলতে পারবো। এখানে সে অনেকগুলো কথা বলছে। জাজ যে সেন্টেন্স দেওয়ার আগে, তাকে লাইফ ইমপ্রিজনমেন্ট দেওয়ার আগে যে ঘটনাগুলো ঘটেছে, কিভাবে তাকে হত্যা করেছিল, এগুলো সব একের পর এক বলে যাচ্ছিল। এবং সেখানে আপনার বলছিল কি যে নিকি অ্যালেন, ওই মেয়েটা, was lured to a derelict building where she was murdered, okay, then by this man. এই ম্যানটা হলো কি একটা খুবই একটা মানে অশুভ একটা, মানে খুবই একটা খারাপ মানে চিন্তা ভাবনা। এই যে সেক্সুয়াল ফ্যান্টাসি, আপনার ইয়াং না, একদম চাইল্ড, মানে সেক্সুয়াল ইয়ার মধ্যে, মানে অ্যাবিউজের মধ্যে। এবং তার অনেকগুলো কনভিকশন ছিল প্রিভিয়াসলি, অনেকগুলা ক্রিমিনাল কনভিকশন ছিল। সে অনেক বছরের জেল হাজত হয়েছে তার। এবং যখনই মানে তাকে নিয়ে যাওয়া হয়েছিল, এবং এখানে বলছে কি, জাজ বলছে কি, ফেট ওয়াজ সিলড, যে সে বুঝতে পারছে যে তার ভাগ্যটা একদম মানে সিল করে দেওয়া হয়েছিল। when she screamed and Boyd decided to kill her to silence her. এবং তাকে যখন মানে স্ক্রিমিং করতেছিল, তখন তাকে সাইলেন্স করছিল এবং তাকে কিল করার জন্য চেষ্টা করছিল। এবং he struck Nikki in the face to hurt her up, তাকে আঘাত করছিল তার মুখের মধ্যে, and pushed her into the pitch black building, একটা একদম পিচ কালো বিল্ডিং এর মধ্যে, একদম অন্ধকার একটা বিল্ডিং এর মধ্যে তাকে পুশ করেছিল। এবং জাজ বলছে কি, she must have been terrified, সে খুবই ডেফিনেটলি খুবই টেরিফাইড হয়েছিল এটা দেখার পরে। এই কথাগুলো জাজ বলছে। তারপরে জাজ বলছে কি, she must have quickly known she was trapped, Mrs. Justice Lombard said. এবং সে বলছে কি, যখনই তাকে এমন অবস্থায় নিয়ে গেছে, সে বুঝতে পারছে সে একটা ট্র্যাপের মধ্যে পড়েছে, তাকে একটা ট্র্যাপে ফেলছে, সেটা সে বুঝতে পারছে। তারপরে আমি শুধু মানে মেইন জাজের কথাগুলো মানে উল্লেখ করছি, এবং সে বলছে কি, her fear as she saw you lurching towards her in the dark was unimaginable. তুমি যখন তার দিকে আগাইয়া যাচ্ছিল, তখন তার যে ভয় ভীতি যেটা ছিল, এইটা অকল্পনীয় ছিল। জাজের এটা রিমার্ক, সেন্টেন্সিং রিমার্ক। It must have been truly terrifying experience for this 7-year-old girl. মেয়েটার বয়স ছিল মাত্র 7 ইয়ার। এটা খুবই টেরিফাইং এক্সপেরিয়েন্স ছিল এই 7 বছর বয়স্ক এই মেয়েটার জন্য, বাচ্চাটার জন্য। Nikki would have endured unimaginable fear as Boyd pursued her inside the old exchange building, she said. এবং জাজ বলছে কি, সে ডেফিনেটলি সে একটা অকল্পনীয়, আনইমাজিনেবল একটা ভয়ের মধ্যে ছিল, সহ্য করতেছিল, যখন তাকে ওই ওল্ড একটা ডেরিলিক্ট বিল্ডিং, পরিত্যক্ত বিল্ডিং এর মধ্যে তাকে নিয়ে যাওয়া হয়েছিল, এক্সচেঞ্জ বিল্ডিং এর মধ্যে। এবং জাজ আরো বলছে কি, মার্ডার হ্যাড শকড অ্যান্ড bewildered, এটা খুব বিশাল একটা শকের মধ্যে ফেলেছিল এবং অনেক বিভ্রান্তির সৃষ্টি হয়েছিল এই মেয়েটার মার্ডারের পরে। The community of Hendon in the east of Sunderland for 31 years, and as time passed, Boyd would have thought some relief that he had got away with it. মানে এটা অনেক মানে বিভ্রান্তি সৃষ্টি করেছিল কমিউনিটির মধ্যে, এবং সান্ডারল্যান্ডের 31 বছর হয়ে গেছে, পুলিশ কোনো কিছু তদন্ত করে বের করতে পারে নাই, এবং এই লোকটা তখন সে মনে করছিল কি, সে হয়তো এখন প্রবলেম থেকে আউট, হয়তো তারে এখন আর ধরতে পারবে না, অনেক দিন হয়ে গেছে, কিছুই হচ্ছে না। However, the science of DNA had also advanced in the decades since her murder. এর মধ্যে অনেক বছর, ঘটনাটা ঘটেছিল, মার্ডার করেছিল 1992-তে, এর মধ্যে 2017 সালে সায়েন্স তো অনেক অ্যাডভান্স করেছে, ডিএনএ অ্যানালাইজ করে ডিএনএ গুলা ম্যাচ করলে তখন তারা খুবই ইজি হয়ে যায় একজনের অপরাধীকে শনাক্ত করতে, and which allowed detectives to match samples from Nikki's clothes to her killer. এবং নিকির ওই বাচ্চাটার ক্লোথের মধ্যে যে ডিএনএ গুলো ছিল, সেটা ম্যাচ করছে ওই কিলারের আপনার মানে আপনার ক্লোথের ডিএনএ। এবং Justice Lombard said under current rules she would have jailed Boyd for a minimum of 37 years, and she had to comply with the sentencing regulations in 1992, which suggested a lesser sentence, albeit well in excess of 20 years. এটা হলো তার লিগ্যাল এক্সপ্লেনেশন, তখন কিরকম সেন্টেন্স দিত আর বর্তমান প্রেজেন্ট টাইমে যখন সেন্টেন্স দিচ্ছিল তখন কিরকম হবে, এগুলো সে এক্সপ্লেন করছে। এবং নিকি wasteland outside the old exchange for a sexual purpose, the court was hard. She was lured to wasteland, একটা পরিত্যক্ত জায়গার মধ্যে তাকে নিয়ে যাওয়া হয়েছে। এবং আরো অনেকগুলো রিমার্ক আছে। This is what happens families like mine ওভার অ্যান্ড ওভার অ্যাগেইন। আমি পড়ার চেষ্টা করছি, জাস্ট মেইন কথাগুলো বলছি। এখানে তার প্যারেন্টসরা বলছে কি, এরা এর যে সাজা দিয়েছে এতে আমরা হ্যাপি না। দিস ইজ হোয়াট হ্যাপেন্স টু ফ্যামিলিজ লাইক মাইন, ওভার অ্যান্ড ওভার অ্যাগেইন, ইনজাস্টিস। এটা তার মানে ফ্যামিলি মেম্বাররা বলছে। এবং তারা বলছে কি, তাকে রাখার দরকার ছিল প্রিজনের মধ্যে ফর হোল লাইফ, কোন সময় তাকে ছাড়ার দরকার ছিল না। এবং নর্মালি যেটা হয়, মনে করেন লাইফ ইমপ্রিজনমেন্ট দেয়, তারপরে জাজ একটা মিনিমাম টাইম সেট করে 20 বছর 30 বছর, মানে ওই মিনিমাম টার্মটা তাকে মানে থাকতেই হবে প্রিজনের মধ্যে। ওর পরে নির্ভর করবে প্যারোল বোর্ডের উপরে। তারা যদি মনে করে সে কমিউনিটির কাছে তখন আর রিস্ক না, তখন তারা কনসিডার করবে তাকে কমিউনিটির মধ্যে ছাড়া যায় কিনা। She was 25 when Nikki was murdered, and was accused of being a bad mother. কমিউনিটির লোকজনরা তাকে মা হিসাবে খারাপ মা বলত। With local people angry towards me and not towards the person responsible. এবং তার মা বলছে কি, আমাকে হেট করতো, কমিউনিটির মানুষরা আমাকে ব্লেম করতো, আসলে যে হত্যাকারী তাকে তারা কোন সময় দিয়া দিতে পারে, দোষ দিতে পারে, কারণ তখনও তো পুলিশ তো তাকে শনাক্ত করতে পারে নাই। She said Boyd destroyed her family's lives, and she said she had fought tirelessly and endlessly for justice. এবং সে বলছে কি, এই লোকটা আমার পরিবারের মানে সমস্ত কিছু ধ্বংস করেছে, আমাদের পরিবারের, আমাদের জীবন, আমাদেরকে সে ধ্বংস করেছে। এবং আমি ফাইট করেছি ফর টায়ারলেসলি অ্যান্ড এন্ডলেসলি, অবিরাম ভাবে, অক্লান্ত ভাবে, ফর জাস্টিস, বিচারের জন্য আমি ফাইট করে গেছি, আমি বন্ধ করি না, আমি থামি নাই। এই কথাগুলো আপনার তার মা বলছে। এবং ফাদার হইল কি, মানে বাচ্চাটার মেয়ে নিকি ফাদার, he said he was 28 when Nikki was murdered, and from that night my life changed. যখন আমার মেয়েকে হত্যা করা হয়েছিল তখন আমার বয়স ছিল 28 বছর, এবং ওই সময় থেকেই আমার লাইফটা একটা চেঞ্জ হয়ে গেছে। In a statement he said he felt anger and hatred. সে খুব মানে অ্যাংরি ফিল করছিল towards the killer, ওই কিলারের জন্য, and would never be able to forgive the man responsible. এবং যে এগুলোর জন্য দায়ী, এই কথাগুলো নিকির বাপ বলছে। এবং তার বাপের নাম হলো ডেভিড অ্যালেন। এবং সে আরো বলছে কি, the devastation he felt was describable. যে আমি যে ডেভাস্টেশন ফিল করেছি, আমার যে এরকম একটা প্রেসার যেটা আমার উপরে আসছে, যে একটা বিধ্বস্ত অবস্থা, এটা ইনডেসক্রাইবেবল, এটা একটা অবর্ণনীয় একেবারে। এই কথাগুলো সে বলছে। এবং আরো অনেকগুলো পয়েন্ট আছে যে পুলিশ বলছে, নর্দাম্বিয়া পুলিশ বলছে কি, ইনিশিয়ালি চার্জ অ্যানাদার পারসন মিস্টেকেনলি, তারা আরেকজনকে মানে চার্জ করছিল, কিন্তু পরে দেখছে যে ওই লোকটা মানে আসলে কোনো দোষী না, ওর ওর কোনো দোষ নাই, এবং তাকে তখন এটা স্টপ করেছে, এটা রং তারা ইনভেস্টিগেশন করেছিল। তারপরে তারা ডিএনএ আবিষ্কার হওয়ার পরে তারা আসল লোককে শনাক্ত করেছিল। দর্শক, সময় শেষ হয়ে গেছে। আজকের প্রোগ্রাম আপনারা কাল সকাল সোমবার 9:30 থেকে 11টা পর্যন্ত আবার এনটিভিতে রিপিট দেখবেন। তাছাড়া এনটিভি ইউরোপের ফেসবুক, ইউটিউব, টুইটারের মধ্যে, ইনস্টাগ্রামে লগ ইন করলে আপনারা প্রোগ্রামের লিঙ্ক পাবেন। আপনারা সলিসিটর শাফিউল আজম, আজাম এন্ড Co.Solicitors এই নাম দিয়ে গুগল সার্চ করলেও ফেসবুক, ইনস্টাগ্রাম, টুইটার সব জায়গায়, আপনারা ইউটিউবের মধ্যে সব জায়গায় আপনারা এই প্রোগ্রামের লিংক পাবেন, এই প্রোগ্রাম দেখতে পারবেন। সবাই ভালো থাকুন, সুস্থ থাকুন এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।